So just FYI, you have not recorded any of that.
Yeah, I don't know, yeah. It was recording when I walked away, sitting.
It stopped the recording?
And I mean, David wasn't aware of whether how much of was being recorded earlier, so, I mean, this is the downfall of you using your own system.
Is it recording now?
Yes, it's recording now.
Okay.
I mean, it really doesn't matter.
Okay, I know, I just said it's you're right.
So what you're telling me is that some portions of what we've done here today.
He doesn't know.
It may have stopped, I don't know.
Let's don't talk while it's running.
Okay.
You wanna turn it off?
No.
Okay.
I don't know why.
Okay.
But yes, to answer your question, yes, there's portions that are absolutely not recorded.
Right before we went to break, it may went off a few minutes before it, I don't know. It was recording a few minutes
Okay,
before.
let's
we
just
went
go
to break.
over this deposition topics. Let me ask you this. On the topics for examination, okay, do you have all your audit engagement letters?
Yes.
Have you provided all your financial statements that you audited? You audited financial
So the
statements. final
periods
audit.
that you requested?
Yes.
And when you say, have I provided, do you mean is it
On
on
that,
that flash
yes.
drive?
Uh-huh.
Yes.
Okay. Currently, the 2025 audit is not being considered, undertaken, or any work done on it for fiscal year ending 2025/26 year. Is that correct?
We are not working on an audit for the year ending February 28, 2026.
Was there any reason that you're not working on it that was discussed with any principals or the board or anything?
I don't know why we are not working on an audit for that period.
Did you discuss anything about the retention or non-retention of you with respect to that audit with anybody at the board?
I do not believe so, no.
Okay, and with Rise either?
Correct.
Okay. So you know no complaints with your work from Rise or the board?
I'm not aware of any communication to us that was complaints.
Okay. What computer system do you use for doing your audits?
It's CCH Pro System FX engagement.
Have you ever done an audit on that system and then gone in and modified it on a different system? For the park?
On my system,
Have you ever made any changes to these audits after they were produced in that software system?
there was the one that you mentioned previously about 2025 year end. There was that number in the footnote that was incorrect, and we updated that.
Nothing
There
else.
could have been another one previously. I don't recall any that happened though.
Did you do any special kind of accounting for the generator project topic number 8 and the special assessment? Did you examine that project and the assessment in connection therewith?
We looked at the project costs and made sure that the project costs were accurately reported and that the special assessment was recorded in accordance with what was approved by the board of directors to be levied. Is that what you're asking?
And did you yourself, you're familiar with that project?
I remember some high level details.
Was Nicholas working on that accounting?
I don't remember if that was in 24 or 25. Nicholas worked on 25.
Okay, so the special assessment itself was first announced that it was in December of 2024. They sent out a notice in December of 2024 that it would be imposed March 1st. We went to court and the judge directed them to take a vote. We had a vote on February 11th of 2025. The assessment was due March 1st of 2026. So, knowing the fiscal year ending, that tells you something about how much information would have been available to you for accounting for that. Can you tell me what you recall about looking at what was done the fiscal year ending 2025 was coincidental was when this special assessment's being assessed. You aware of that?
I don't recall the timeline, sorry.
Well, you had some accounting done about that, but I'm trying to figure out what you actually looked at. See, you have generator in here in the fiscal year ending 25. And it's as an expense here, do you see that?
Yes,
How much is that expense?
$702,426.
Now, what would that mean to you that that expense is comprised of?
I'm going off an assumption because I don't recall the specific details, but there would be a contractor involved and potentially an engineer perhaps in that line item, but I don't. I'm just making assumptions.
Okay, so you don't know if that was the purchase of the generator as opposed to the installation, you're right?
I don't recall the details that made up that number.
Were you consulted with how to account for both the generator project and this loan that they were talking about?
I don't think that they being Rise or the board gave us any direction on how they wanted it recorded. I think this was us helping them get it into the right format, if I remember correctly. But I don't recall any communication from them saying we want it to be this particular way or that particular way.
Was there, okay. If any amounts were prepaid toward the generator project on or before the end of that fiscal year that you did the audit for, where would you have accounted for them?
Prepaid is tough because it depends upon whether it's a refundable deposit from the vendor or whether this is payment towards the construction costs themselves. And so there would have to be an assessment done on, did the actual work commence, or was it a true down payment that's refundable? If it's a true down payment that is refundable, then typically you would put that on the balance sheet as a prepaid cost, and you could wait for the cost to be incurred to go into the financial statements as an expense. If it's a payment on the project and the project is commencing, then it's difficult to know, okay, well, where were they on a specific day on the project? But typically it would be an expenditure if the project's already started and there's work being conducted.
My question, we can come back to that in a second. My question was really about the people paying, so I was talking about the people paying in advance for this special assessment.
Homeowners.
Yeah.
Okay,
exactly.
sorry.
Yeah.
Can you rephrase the question this way I make sure
Okay.
now that I have
So,
right framing?
So let's assume there's a generator project and there's been a vote, let's just assume it's valid, and the first assessment is made, but some people have paid in advance for their share of the generator. How would you expect that to be built?
Okay, so if a homeowner pays in advance of the assessment, it goes as a credit on their account, and that gets reported on the balance sheet as a prepaid assessment. And it's just a balance that people have overpaid on whatever charge, because it hasn't been assigned to a charge yet, so it's just called prepaid assessments.
Okay. Now, can you look at that financial statement and see if they've accounted for any fees for prepaid assessments that could be attributable to this generator?
Yes.
And how much is that?
$303,441.
So, were you aware that there was a loan taken out for, well, first of all, you were aware there was a loan taken out by the association in connection with the generator project?
I know they have a loan. I can't remember when the loans were taken out and what the specific project was for at the time when they were taken out, but I know they have loans.
So, if the association took out a loan for the express purpose of financing those owners who did not prepay the assessment. And the total assessment was 2.2 million. As of the date of this, year-end, fiscal year 2025 year-end, 300 and some odd thousand was already collected, right?
Okay, so I think you started with the loan and then you finished with the prepaid
Yeah,
assessments.
and
Can you
okay, if you're
clarify,
only
please?
borrowing the amount that to finance the people who didn't prepay, right? Then as of the date of this, if you started with a 2.2 project, how much would you need to borrow?
I guess it would depend on when you need to start the project and if you knew that you were going to get the 300 right away. I would assume you would borrow the whole balance, or you maybe sign a note for a line of credit that allows you to get the whole balance.
But if you've already collected 300,000, then you only need 1.9.
I suppose it depends on what other needs you might have in the community and what the total, if there's gonna be cost overruns potentially that you wanna be prepared for.
Well, the project is a $2.2 million loan, and it is supposed to be solely to finance $2.2 million worth of owners' assessments for that project. So if $1 million were collected in advance, and the association had a line of credit up to 2.2 million, you would expect them to borrow exactly what they need to finance the other owners, would you not?
Objection 4.
I guess I'd have to look at the whole picture and decide what my risk profile is on that future debt service. If I was a board member, I would say some homeowners paid in advance, so we could pay the loan down for that, but then we're gonna have more people paying over time, presumably, and what if they slow pay or don't pay timely? We don't wanna put ourselves in a position where then we have no cash to make a debt payment when those come due. So you'd wanna keep a cushion of cash to make sure that you don't skip a debt payment if that comes up. So you'd have to be a little bit cautious before saying I'm just not going to borrow it. And then as I mentioned too, there's potential cost overruns. I know you said it's 2.2 million, but construction things happen, so I would want to have a contingency for that as well.
Then the special assessment disclosure to the owners should say all that.
Those are future decisions the board might make.
No, I mean the disclosure to the owners about how much they're borrowing and how much they're paying should say all that stuff you just said. If those were factors that you think that the board would be entitled to do.
Form.
I don't know what the board is required to disclose on a debt financing.
Yeah. So if the special assessment is described as just lending the money, as being a limited $2.2 million, and the owners are either paying in advance or paying over time, the loan should only be needed for the ones who are paying over time and not the ones who pay in advance, right? Otherwise, they're not being told the truth about what the loan is for.
Objection
I
4.
mean, you're rewriting the agreement form, aren't you?
Form.
I'm not rewriting an agreement for.
Because my premise was, if you have a $2.2 million loan for the express purpose of financing at 7%, the amount that the owners do not prepay, and they get $1 million prepaid, under those premises, they should only borrow 1.2 million, right? Now, you're saying it might be prudent to do something else, but the premises I gave you is a loan was made for the express purpose of financing the owners who did not pay in advance, a limited sum of 2.2 million.
So you're saying in a hypothetical fact pattern where you said we're gonna take out a loan
For 2.2 million.
for only the dollar amount that we need to cover people who don't prepay,
Yes.
and the board communicated that to the owners. The
Expressly.
owners knew that, then I assume that your fact pattern would make sense, that you would only issue 1.9 million.
And that's why you'd get a line of credit with a 10-month out date so that you know how much is prepaid. We do that. Did you do any accounting on something that looked like that?
We did no projections of future years to determine what might happen to the assessments or how much they might decide to draw on the loan.
Did you look at the loan?
The loan that existed as of February 28th, 2025, yes.
That loan was actually for 3.7 million, wasn't it?
The footnote disclosure says 3.7 million.
And what was the percentage interest?
The footnote says a fixed interest rate of 7% for 10 years.
And did they say in the footnote that they were rolling up into that loan an existing debt that had matured?
It does say that it was used to finance construction projects and refinance the existing loan.
Did you know what the existing loan amortization schedule was?
We have one in our files.
And was it amortized to 2029?
I don't recall. We could check the files and see, but I don't remember off the top of my head.
Did you discuss this loan with anybody at the management company?
We requested the documents and
Just for
the
the audit?
records to make sure that the numbers were accurately reported.
So just for the audit, you didn't discuss it in terms of the, whether it was prudent or not to enter into this loan?
Correct. We didn't do any consulting on whether a loan is the right approach or not the right approach.
And you didn't do any consulting on whether or not the association was in a financial position to underwrite this because of those risks you were just talking about, right?
We didn't have any correspondence with them about whether a loan is affordable, or we were not consulted when this loan was issued.
Did anybody ask you for any advice on whether or not the generators should be triaged over elevators or pipes?
We didn't have any conversations about order of repairs and which ones are most high priority.
Have you ever talked to or given advice to the park about paying loan debt service payments and where those funds should come from in the budget?
I don't recall having any conversations like that.
The homeowners are told that there's approximately $30,000 a month put into reserves. We'll strike that. Right now, there's approximately $30,000 a month put in that goes to paying interest on loans. Okay, where should that be moved? In what category of expense should that come under?
Are you asking about where the interest should be recorded?
Yeah.
Or-
Mm-hmm. What fund should be used to pay that interest?
Well,
Those are two different questions.
Okay. Let me ask, what account should be used for payment of that interest? Should it be an expense? Should it come out of reserves? Should it come out of operating? Where should that come out of?
all of the funds have expenses.
Yes.
And so,
Which fund should it come out of?
sure, it should come out of the fund that has the loan reported in it. And historically, that's been the replacement fund. That's where the interest would come out of.
So, on this new loan, that's been everything rolled up, we're paying $30,000 a month, then you're saying it would be appropriate accounting to take $30,000 a month out of our replacement fund to fund a loan for the generator and the pre-existing debt. Is that right?
If the debt is in your replacement fund, then pretty much have to service it in that fund because each fund is individually balancing.
Who put the debt in the replacement fund? You?
I don't recall how that came about. I know Rise has their own fund accounting, and typically this matches it. Sometimes we will recommend changes to them. I don't know if we did recommend a change on that one in particular. It could be our recommendation, or it could be this is what Rise had all along. I don't know.
Can you look and find out?
Maybe.
Yeah. That's 2021. Mhm. That's the problem right there. That's what I'm trying to find out. Did you find it?
This is the 2021 financial report that Rise provided us.
Mm-hmm.
And in that report, you can see that the loan is reported in the reserve fund.
Well, now that's a loan that, so if they procured that loan in order to make a capital improvement, it should have gone there, right? But if they procured that loan and then spent it on operating, it shouldn't go there, right?
Generally, yes. If it's spent on capital, you would have it in the reserve fund. If it was an operating, like if you needed it to pay insurance, that would typically go in the operating fund.
If the board gives you the reserve advisors report, we'll start there. The board did give you the reserve advisor reports in 2018 and in 2023, correct?
I don't know when they gave them to us, but we have copies.
And they were the years that they were produced by reserve advisors were 2018 and 2023, correct?
Yes, I believe so.
And that, the supplemental information you're supposed to provide under SERA, it requires you to look at that report and provide the information that you provided at the end of each one of these audited statements, right?
Right, the association has a responsibility to put that in the required supplementary information.
If they have some other budget that they're adhering to rather than that one, they're required to provide that to you, correct?
You're talking about a budget for the reserve fund that would be different than the reserve study?
Yeah. I mean, that's the only one you've been given, right?
Typically, there's not a budget for the replacement fund aside from the reserve study. If there was one, we probably didn't ask for it.
No, I'm not suggesting to you that you need to ask for it. What I'm saying is, you're required under SERA to report on the one you're given, and they're required to give you one, right?
They're not required to have a reserve study, but if they have one, they're required to report it as a card supplementary information.
And they required to provide you with that information so that you can do that supplemental report.
Right, it's their report, and it should be in there if they have one.
And if they are only collecting if the declaration in bylaws require them to have an amount contributed to reserves to provide for the replacement of depreciable items, capital improvements, then would it be prudent accounting to spend all or substantially all of that money on one item, like cameras, when you have multiple items in the list, including elevators and pipes for $5 million?
Chicken farm.
And that's the HOA's decision. I don't know that there's a legal requirement that they must follow this reserve advisor's report to do these repairs at that timing.
And if they fail to, then according to the thing you told us, you put in your report, if they fail to follow this prudently and spend all the money on something like cameras, then when the pipes go out or the elevators go out, according to what you put in the audit, they could just issue a special assessment to the owners to pay for the difference, and that's how they make up for it, right?
Chicken farm.
There's a footnote in here that says that's one of the potential options to recover that funds if they have a repair that they need to make and they do not have the funds available.
And that's where we took a break when I was showing you that the bylaws to see if you had ever figured out whether or not those bylaws in fact give them that option, because we were going through that section and I was trying to figure out where you got that notion. And Article 4 is the bylaws. Have you ever looked in those bylaws to see if there's any section called special assessments that allows them to do a special assessment for capital improvements?
I don't recall reading the bylaws to determine whether or not the bylaws say a special assessment is allowed.
So if the management policy is one that's contrary to the bylaws, you would not have noticed that. You're not distinguishing management policy from what the bylaws say when you make your statement. Is that correct?
We want our statement to be factually correct, and that was our understanding of what their abilities are.
Well, I can understand how you get your understanding from them if you're talking about a policy. What I don't understand is how you can get your understanding from them if you're supposed to go read the document and it doesn't say that. So I know you're supposed to give us the statement of board's policy, right?
Yes, their funding policy.
And then you're supposed to give us a statement of what the rules or the law allow, right?
Objection form.
The HOA documents or the law.
I think you can add clarification to that if you would like.
Uh-huh.
So if you said I wanted additional information about the bylaws or declarations, I think you can.
Here. I think my question was, do you have an obligation that's different from the one about the board's policy to actually read those documents and report your conclusion as to what they say?
I have a responsibility to make sure that the financial statements are materially correct, which includes the notes to the financial statements. And so if we are aware of anything that we think is not materially correct, we will fix it. We will do research and try to determine if it is materially correct. We don't have a requirement that says you must read the bylaws or you must read the declarations to determine if X, Y, Z is accurate or not accurate.
I thought you were supposed to report on the requirements in the statutes or in the governing documents for the obligation to collect special assessments to pay for capital improvements.
My understanding is that the footnote that's in the financial statements does report that.
But you cannot corroborate any place in the document that does in fact say the board's entitled to make a special assessment for that purpose, can you?
I don't have a declaration with a highlighted section that mentions special assessment specifically. I can't point to something that I can give you.
And you can't point to any work that you've done to corroborate that statement.
I don't have any files that say I read the declaration and it says this, and so I typed it in the report. I don't have anything like that.
And you know that the primary users of the financial information provided by the CERA are the unit owners, right?
Section 4.
I'm making sure that the financial statements are accurate for any reader of those financial statements.
Do you understand that the primary users of that financial information in that report are in fact the unit owners? Is that not one of the unique characteristics of common interest realty associations?
I would think if I'm an owner, I would like to have a copy of those financial statements, and I would be a reader of them.
Well, in fact, that's what the auditing board said to you in their circular in AAG Circular 1.29 in section 1.33. The primary users of the financial information of the CERA are unit owners. Okay, so whose periodic payments of assessments or carrying charges enable this CERA to perform its functions. They're primarily interested in information indicates whether assessments are used for the designated budgetary purposes and whether adequate funds have been accumulated for future major repairs and replacements. That's correct, isn't it?
Judge.
You would agree with that?
As I stated, if I were an owner, I would like to have one, so I would be a user of the financial statements.
So you can understand that if unit owners are reading your stuff, they are being told by you. Let's check this. As of today's date, with what you know is how much is in the replacement fund that would be available as cash to pay for any repairs if the generator went out? I mean, if a elevator went out.
As of today, I don't have anything beyond the financial statements that I issued in February of 2025.
And as of the end of February 2025, other than the money for the generator, what was there to pay for an elevator repair or a pipes repair?
We can look at the financial statements and I can tell you. The financial statements for February 28th, 2025 reported cash in the replacement fund of $97,902, but they also had liabilities of $1,485,000. So there was a deficit of $1.3 million.
So do you know how much the reserve advisors had advised should be in the reserves at that fiscal year end?
Reserve Advisors does a projection.
Yes.
And then gives you a funding plan.
Yes.
And on that funding plan, as of the February 28th, 2025, they had $1.6 million in the replacement fund on that
They recommend
schedule.
that they recommend to meet the schedule.
Correct.
So, if I'm reading you correct today, you have said that it is not your job to look for fraud or identify fraud or theft.
Correct. Our job is to issue an opinion on the accuracy of the financial statements.
If the employees were told in a year that the monies collected for their bonuses were stolen, would that be something that should be reflected in the financial statement?
I guess there's two questions there. One would be, depends on the dollar amount, if it's significant to the financial statements. Two, you don't want to disclose any information that could prohibit an investigation, so that wouldn't necessarily go into the financial statements. If we became aware of fraud, our responsibility is to report it to the board and encourage them to take appropriate action.
If the monies were collected by RISE for the Christmas bonuses and then they told the employees they were stolen, would you expect that to be covered as an item of insurance or just covered by the owners? How would that be handled accounting-wise?
I don't know if the insurance would cover a claim like that or not.
employee fidelity. You know, people that handle, you don't expect a management company to have, fidelity insurance that bonded and insured for handling money.
If I were a board member, I would hope that they would have that, but I don't know, even if they did have it, if the insurance carrier would honor a claim or something like that, I don't know.
Have you ever looked at the contracts that Rise has with the employees?
Don't recall looking at any specific employment contracts.
If you suspected fraud, I know you're not looking for it, but if you suspected it, who would you tell?
The board of directors.
What if they were in on
Well, there's not much we can do if it's at the top level. We have some duties that I haven't luckily been faced with that requirement. Typically, if the board is involved and they're conducting the fraud, I believe our professional guidance says that we should disengage from the client. I don't believe we have the ability to go report it to any other third party.
it? If it involved insurance?
I think it doesn't matter who it involves. I don't think with our confidentiality requirements that we're allowed to. Now, I'd have to brush up on that because the situation fortunately has not happened to me, but typically our responsibility is to report it to the board and encourage them to take the appropriate action.
And so if I understand what you're doing right, then if an invoice is presented to you as being paid by Rise, you're not looking behind any of those invoices to see if that is a company that's owned or affiliated with Rise. You're not doing any spot checking or anything.
If we have some suspicion that there could be a relationship that would be of risk for the association, we might do some investigating. But we're not doing that on every single vendor.
No, I'm not suggesting that, but do you even have a way to flag, like say all the invoices look the same? You know, or something that, you can tell that they were created or?
I mean, we train our staff on what to look for, and we're looking for unusual invoices that lack, qualifying markers in terms of date, an address. Does this look like a fifth grader put it together, or does it look like it's an actual vendor? Are we aware of who the vendor is? Do we see them at other communities? So we're looking at all of those factors to determine, does this look to be legitimate? And we're also looking at what the board has discussed and what's in the minutes and all that kind of information as well.
When you're letting Rise take the employees over and then lease them back to the company, you don't examine those contractual relationships at all. You just accept that as an acceptable business practice, right?
I guess I'm looking at the board has made a decision to contract these employees through Rise, and I'm looking to make sure that Rise is charging them in accordance with what the board expects.
So you are looking for a functional board that actually reviews the management company's activities themselves.
Objection form.
It's important to have a board that's providing effective oversight.
And have you ever read any of the hallmarks of a HOA that's gone bad, where one officer affiliates themselves with the management company and the rest of the board is non-functional, and that entity becomes entrenched and can actually take over the board and is in a position then to utilize that position for personal profit.
Section 4.
I've heard of examples like that. I don't know that I've
Do
seen one.
do they tell you in any of the training that you get how to be alerted to that situation so that you're alerted to whether or not that's going on in when you're doing the audit?
I mean, yes.
What are the flags for that?
Well, it would be ineffective oversight from the board. I guess a lot of these communities are smaller, so we're looking at a lot of the transactions, and so we're looking for vendors that are significant, that could be unusual or taken advantage of.
You look for whether or not there's, an entrenched board, say the same, board officer, has been there for 10 years and its management's not changing, the board's rubber stamping the same entrenched officers.
The tenure is not typically too concerning. There's a high level of turnover with management in particular, so the dynamic seems to be changing a lot. So it's not very common, and it wouldn't necessarily be a concern.
Have you ever heard of entrenched management? That word, that phrase?
I'm not familiar with what it refers to.
Is there any particular qualifications you have? Do you attend any training for HOA accountants?
No specific HOA training classes that I can think of in the recent years.
Are you a member of any group of accountants who are affiliated with or do a lot of HOA work?
I'm not aware of an organization that we are participating in. The firm participates in CAI, but not accounting specific. I'm not aware of it.
Not any group of CIRA related accountants?
No.
And you're not a member of any community association group that has any kind of training that you go to?
I'm not aware of that.
Do you primarily do HOA accountancy?
Primarily, you mean in terms of, could you define
is that
primarily, or?
60% of your work?
No.
What is the rest of your work?
Nonprofits and governments.
Jody Blazik.
I know the name.
Yeah, okay. So most of the nonprofits that you deal with have pretty functioning boards, don't they?
Yes, they're mostly charter schools, and so they have typically strong management.
Can you tell me if it was a continuing depletion in the amount available in the reserve fund over the period of time that you have audited the park?
I can tell you what's reported on the financial statements here.
Mm-hmm.
And if we were to take 2 years in particular, 2024, the year ending February 29th, 2024, showed a deficit in replacement fund of 1.37 million.
Mm-hmm.
And February 28th of 2025 showed a deficit of 1,387,000. So that's a little bit larger deficit than it was the year before.
And what was it in 2020?
In 2020, it reports a deficit of 2,056,638.
So does that have to do with the way that they're accounting for that loan? Because as I understand it, the loan that was rolled over into this $3.7 million loan was what accounted for most of the 2020 deficit. Is that correct?
I don't recall exactly what caused it. I think your question was, why is it improved?
I think they just moved the loan, is what I'm saying.
Objection form.
I know they refinanced it in the 2025 year.
And reduced the payments. So you don't know exactly how much of that was a loan and how much of this one is a loan?
I do.
Okay.
It's on here.
Okay.
So in 2020, the loan balance was 2,792,000.
Mm-hmm.
And in February 28th of 2025, the loan balance was, I have to add the two numbers together, it's 1.5 million, a little more, give or take some change.
How much cash is actually in the reserves at each of those points?
As of February 29th of 2020,
Mhm.
there was 791,000 in cash.
Mhm.
As of February 29th of 2024, there was $104,000 in replacement fund cash.
Mhm.
And in February 28th of 2025, there was $97,902 in replacement fund cash.
Can you tell me what, in, August of 2024, the board announced that they had purchased a generator for $693,000, at the board meeting in August, well, it was actually September 5th. It was the August board meeting on September 5th in 2024. And they had announced they purchased a generator for $693,000, but they were unable to even pay the down payment for that purchase and had to borrow that from Rise. Was that discussed with you or revealed to you?
I don't recall the facts that you're mentioning.
If a board commits to make an acquisition of a item that needs to be voted on by the owners and doesn't even have the money to put the down payment on that item, would that be prudent in your opinion?
Section 4.
It's not wise for someone to buy something if they have no way to pay for it.
Okay, I don't have any other questions. Thank you. And I'm sorry about that video. You'll see how messed up that is. And Corey, are you gonna make it?
I'm gonna,
I just told her.
You want me to get David to run you over there?
no, I can get an Uber here real
No,
quick.
he
I can drop you off.
It's no big deal. No,
If it'll make
You have any
difference.
questions?
No.
no.
If
Okay,
it'll make
off
a
the record,
difference.
1701.